Live now. All right. So we're live now. Before we get to the verdict, in case anyone doesn't know who we are, and while we're waiting for people to get on, let me see. All right. So while we're waiting for people to get on, I'm going to do some quick introductions, who we are, why we're here, why we're going to talk about the verdict. We're going to go through what the verdict is and what's going to happen now. So I'm Peter Tragos. Most people on the page know who we are, since in fact this is our Instagram page, but I'm Peter Tragos. I do mostly personal injury. I do some criminal defense. So for this, I brought on my dad, who does basically all of our criminal defense, former prosecutor in the state courts, former prosecutor in federal courts, so he knows both sides of what everybody's going through, and all the lawyers in the courtroom for the Derek Chauvin trial are going through what it's like to sit next to your client while he's about to be read this verdict and potentially a prison sentence. So he'll tell you what that's like to sit next to defendants. I've done it before too, and it's miserable. So to start out, we have some people on, so we're just going to jump right into it. To start out, let's get through what the jury's actual verdict was. And to start out, count 1, second-degree murder, which is basically felony murder, committing a murder while you're committing a felony, or a death while you're committing a felony. He was found guilty. Count 2, third-degree murder, which is committing a dangerous act that turned into a murder, guilty. You'll catch a common theme. Third count, second-degree manslaughter, which is like a negligent killing, guilty. Guilty on all counts. So the first question that I want to ask, just for everyone's edification, Dad, explain the difference between lesser includeds and separate charges, because he was found guilty on all of these. If these were known as lesser includeds, they wouldn't have had to go on to the other counts, right?
That's correct.
Okay.
These were separate charges. There was a guilt or innocence on all 3 of them. And like I said, lesser includeds means that charge is included within the main charge. That's not what happens up in Minnesota or Wisconsin. Minnesota. That's not what happens. What happens there is you charge each separate count. You can be found guilty of all 3, and he was found guilty of all 3 because they have different elements. In other words, what you have to prove for each one is a little bit different.
Right, so in this case, they proved all 3 guilty on counts 1, 2, and 3 across the board. So let's talk about why do they, what we call, poll the jury. So if you listen to the verdict, they went through and they asked, do you want us to poll the jury? The prosecution said, yes, I believe. So they went and asked each individual juror, is this your verdict? And each individual juror said yes. Why did they do that?
Because it has to be unanimous. And they want to make sure there are no mistakes. That you don't have one juror later on saying, wait a minute, I didn't vote for that. And it would screw up the entire verdict. So now they have it on the record with a court reporter that all the jurors all agreed on these verdicts.
And what's also important is there are certain cases, especially cases like this, where people might be bullied into voting a certain way. And when you're in the room alone with the rest of the jury, sometimes one person won't feel powerful enough to speak their mind and speak their voice. So the court wants to give them authority in front of everybody to now say, this actually is not my verdict. I did not vote guilty. They all pressured me. I actually wanted to vote not guilty. And then there'd potentially be a hung jury and they'd have to retry the entire case. So that's happened before, and there's some case law on that. And that's one of the reasons that they poll every single juror to make sure this is the verdict that they voted for and wanted in this case after listening to all the evidence, because it has to be unanimous, guilty on all counts, which here it was. So the next thing they talked about immediately after the verdict is the judge asked if the prosecution had any motions to make. And did they have any motions to make in this case?
Yes, and they always have this motion. If someone is convicted in the courtroom, even if they're out on bond, at that point the judge has the authority to revoke their bond and remand them to custody, basically send them to jail. 99 times out of 100, if someone is convicted of a trial, the judge sends them to jail right then, because there is an additional risk of them running once they've been convicted, because now they know they're going to be sentenced.
Okay, and if people have questions, you can put them in the comments. I'll try to figure out how to read them at the end. So let's go through next. The next thing that happened after the verdict was read is the judge gave us kind of a timeline of events as to what's going to happen now. So Blakely you can file your written arguments within 1 week. What is that?
Well, those are the aggravating circumstances and motions for new trial. So first you have a motion for a new trial. You're allowed to tell the judge, because of legal mistakes made during the trial, this trial should be reversed by you, and we should try this case all over again. Again, 99.9 times out of 100, that doesn't work, because judges aren't going to reverse themselves and say, hey, oh yeah, I made a mistake on that ruling. They're not going to do that. They're going to leave that for the appellate courts. So it gives the judge the opportunity, if the judge did feel like he made a mistake, and I've filed those and I've had them granted. Once in a while, a judge will find they did make a mistake and not really realize it until after the trial. But generally speaking, that's not going to happen.
All right, so we're getting a few questions that we're going to ask. So let me ask some of these. One of the questions is, how long does he have to appeal this? And talk about the appellate, just briefly. Talk about the appellate scenarios, what they can appeal, when he can file that first appeal, and what it's going to look like.
I can only give you what the rule would be in Florida. You have 30 days to file your appeal.
Most states are similar, so
Right.
yes, you have a limited amount of time to file that initial appeal, and anything you don't appeal at that time, you waive, right?
That's right. If you don't file that notice within the time limit that they're given, you've waived it. It's over. You can't do it again. You're dead in the water. So you've got to file it within that time limit. But all you have to file during that time limit is your notice of appeal. That doesn't mean you're going to file all your briefs, all your written arguments, all the research you do. That comes later on, because after you file your notice, you have to order a transcript. The court reporter has to type up everything said in that trial. And at that point, you have to file your briefs telling the court what issues there were in this trial that require reversal.
Okay, so this question. I thought that reasonable doubt was all that was needed to be proven innocent. And let's talk a little bit about the difference between innocent and not guilty. If we have officials making comments about what type of verdict should be reached, what kind of standard does this set? So let me ask this in a couple of different ways. First off, talk about the difference between being declared innocent and not guilty.
Well, not guilty just means the jury did not find sufficient evidence to convict you, which means there was a reasonable doubt. Innocent means you didn't do anything, you're totally clear. That's not what jury trials do. Jury trials don't find people innocent, they find them guilty or not guilty.
And the beyond a reasonable doubt is the standard in criminal court. But her second question, or her second question was, if public officials can comment on this. I think she's talking about a lot of the news outlets and a lot of politicians are commenting, this better be a guilty verdict or better be a not guilty verdict or whatever it may be. They comment on that. How does that affect the burden? How does that affect the jurors? And what protections are put in place so the jurors are not affected by comments like that, or supposed to not be affected?
Well, first, it doesn't affect the burden. The burden is still the same. Secondly, effect on the jurors. We can just hope it doesn't affect the jurors, otherwise the jury system wouldn't work. If outside influences, outside of that courtroom, could influence that jury. In this case, that's a scary aspect in this case, because those jurors walk by armored cars to come into the courthouse. They walk by all the protesters to come into the courthouse. They're told not to read anything, read the paper or anything, but you know, there was another killing just in a suburb of that city. We have a congresswoman making comments.
And we have the settlement that happened with
$27 million.
Right.
There was a lot going on around this jury, and all you can do is just say, we sure hope that they kept an open mind.
And the jury, so we just finished a trial. I was in trial last week, all week, and every day when we showed back up, the judge said, has there been anything that's been done that's been a violation of the rules that I've read to you? Any outside influences affected you? Anybody that needs to be off this jury because of something they've read or heard or done since they left the courtroom to when they came back? And every juror had to say no before we proceeded with that day. So I assume the judge did the same thing in this case to each one of these jurors to make sure that nothing was happening that was making them get messed up in this. So next question, I'm getting texted question 2. So another question is, are you surprised that he was convicted of all counts?
No, I think if you looked at the video that I did about the second half of the trial, my prediction was he would be found guilty.
Well, yeah, we all predicted that he would be found guilty. I'm a little surprised that it was of all 3. I thought the jury might split the baby and convict him of third-degree murder and second-degree manslaughter, but maybe not second-degree murder. It makes sense if they're going to find him guilty of second-degree murder. Also, they would find him guilty of the other 2. But I'm a little surprised that it was all 3. I thought the jury might try to be a little more political and just say, all right, we didn't give him the worst, we gave him the other 2. So that's one thing that was a little surprising, but I knew he was going to get convicted based on the evidence and wasn't surprised. A lot of YouTubers disagreed with me in the comments, but... All right, the next question that we got here on Instagram was, how many years does he get? So before we get to that answer, I want to set up something else the judge said. So the judge said in the scheduling, within 4 weeks, there's going to be a PSI done. What is a PSI?
That's a pre-sentence investigation. It's a background check. It talks about your employment, your health, where you were born,
any other
what
crimes
job
you've committed,
you had, prior record, your income, your assets. It just tells the judge everything that can be found out about you and your background.
basically how good or bad of a guy you are in Derek Chauvin's case prior to committing this crime, and that all gets taken into account when determining how long your sentence will be. So we don't know how long the sentence will be at this point. All we know is what the statutory maximums and minimums are. So they have 4 weeks to get that pre-sentence investigation, which is an entire process of interviews, backgrounds, letters. The lawyers still do a lot of work. The defendant gets interviewed a lot. Then they're going to do a briefing 2 weeks after that. And then sentencing is going to be 2 weeks after that. So about 8 weeks from now, we're going to find out what Derek Chauvin's sentence was. Okay, since he was convicted, will his family still get any of his benefits? Because he was a law enforcement officer. Do you know the answer to that?
Well, I'm trying to remember if he was fired or he resigned.
I believe he was fired.
If he was fired, it depends on their contract with their union. It's possible he will not get benefits. He was fired.
I believe his wife left him as well.
Well, because the officer in the suburb that did the shooting, that officer resigned, was not fired. That officer, because she resigned, is going to get all her benefits.
And we're gonna do future videos on that case, since I assume it's gonna blow up now, even after this verdict.
There is something I want to talk about before we talk about the sentence.
Okay.
We do have some hints about what the sentence will be.
Okay, go for it. How long is he gonna be in?
The second-degree murder is a 40-year max. Third-degree murder is a 25-year max, and the manslaughter is a 10-year max. But they have recommended sentences, and their recommended sentences on murders are 12 and a half years.
On second degree?
On second degree and the third degree. They're both 12 and a half years, and they have what's known as aggravating circumstances, which could raise it above the recommended sentence. And in this case, the prosecution is going to put forth some legitimate, what they call legitimate aggravating circumstances where there's some case law. One is child witnesses, where children witnessed it.
Which we talked about. They were actually called, those minors, and we heard them. We didn't see their faces,
right,
but we heard their testimony. So that's something that was big in the trial as well. Those are called upward departures,
yes,
right?
There's upward they call them aggravated circumstances.
Okay, so here we call them upward departures or downward departures, where you can put on evidence that during the sentencing memo, or during the sentencing hearing, you can put on evidence that you think it should be less time in jail if you're the defense attorney, or more time in jail if you're the prosecutor.
Another aspect is going to be law enforcement. Under the color of law enforcement, his authority, he committed this crime.
Right.
And then the other one is going to be vulnerable victim. Was Mr. Floyd a vulnerable victim? When he was handcuffed, lying on the ground, is he a vulnerable victim? That's going to be an aggravated circumstance. So I think we'll hear a lot of that up in the next upcoming weeks.
Okay, and then something else that, I don't know if we got to this. I think I asked, I don't remember you saying it. So right after the verdict was read, the prosecutor asked that he was remanded immediately to prison. Did we talk about that?
Yes.
Okay, so that's something that happened. So he goes back to prison immediately. Bond is revoked. So all of the privileges that he had, basically with the cloak of the presumption of innocence, where you can get bail or bond so you can pay money and get out, go back out in the street, that all goes away immediately if you're convicted, especially of crimes like this. If there are dangerous crimes and they think you're going to be a danger to the community, boom, you go right back in jail, which is what happened to him. Okay, let's see here.
By the way, another thing, so people normally serve 2/3 of their sentence in that state.
Right.
And they're paroled for the last third.
Right. So, okay, so here's another thing. So because he was convicted of all three, and these are not lesser includeds, could the judge sentence him to all of those maxes added on top of each other? So 40 years plus 25 plus whatever, just piling them on top of each other, or even if it's 12 and a half years, 12 and a half years for second degree murder, 12 and a half years for third degree murder, 10 years for manslaughter. Could he add all those up so it becomes 30 years or even 70 plus years?
Well, that's an interesting question because of the elements. If the crimes have all the same elements, then he could
and
not.
The same facts, not elements, but the same facts.
In this case, I don't know if he really could do that because we are using the same facts for almost all of these crimes. So I'm not sure he could stack them. But he sure could give him, for instance, 40 years is the maximum for that second degree murder. He sure could give him the maximum.
I think usually you're not supposed to stack if all the facts lead to the same thing, even if there's little differences in the elements. And even though he was convicted of all three, I guess technically he probably could, but the defense would have a good motion against that.
There's another interesting fact, too, is that a jury will decide the aggravating facts unless the defendant waives his right to a jury.
We've got a couple questions.
The jury waived it. The judge is going to make the decision.
Okay, so the first question is, would his sentence run concurrently? What that means is if they do 12 and a half years for the first count, 12 and a half for the second, 10 for the third, it would all run at the same time. So it would only be 12 and a half years as opposed to consecutively, which means adding them all together. So that's concurrently versus consecutively. Another question. Okay, here's a big one. Your opinion. Did the jury get all 3 guilty verdicts correct? What do you think?
I think they had sufficient evidence to find all 3 of those guilty verdicts, yes. They rejected the arguments of the defense, and there was enough of it. The prosecution put on one heck of a case. I've got to say they did a good job, and in fact, one of the issues that made it did too good a job, but they did a really good job. They had plenty of evidence. There was plenty there to convict him, so I don't think the convictions are unreasonable.
Yeah, I think for sure the first 2, like I said, when I said I thought that they might come back with a not guilty verdict on the second-degree murder, it was more politically charged that they would try to split the baby and not be the bad guys or the good guys for whatever side, and they just want to kind of stay out of it that way, but do their duty as jurors and give a conviction. I think that there was definitely enough evidence for the second-degree murder, for that felony murder, that a murder occurred or a death occurred during the commission of a felony. I also think the prosecution did a good job, kind of for a different reason. The prosecution could have just dove into all of the other circus elements and brought in all of the other things that somebody else asked about, all the craziness in politics, all the craziness from the news channels, talk about the settlement or at least infer it or, talk about it tangentially and just kind of bring all these other factors into play to inflame the jury and make the jury mad and make the jury feel that outside pressure of a full country saying, if you don't get this right, then you're letting an entire race down. You're letting a huge portion of our country down. You're letting an entire political party down. I don't feel like they did a lot of that in this case. Do you agree? I feel like they did a good job of presenting the evidence, proving the elements, showing the facts, and then getting rid of the defense's argument and kind of focusing on the evidence in the case.
Right, and then they also did a great job of making it not an indictment of the police.
Right.
They didn't attack the police. It's one bad cop. And that was a really good idea.
I agree. They even brought a ton of police witnesses in for them.
Right.
I mean, and they used the police to condemn Derek Chauvin. So, they really did not over-politicize it, which I was happy to see and I think was a good move on their part, personally. Because I don't think they're going to be able to be attacked, number one. Number two, it closes a lot of doors that the defense would have had for an appeal. Because if they would have brought all this outside inadmissible evidence and tried to break that part of the case, or try to pressure the jury into doing something, then that can open up something for appeal. So that's really, I think, a good job by them as well, because nobody wants to see this appealed for years. So talk about one other thing. So we had a question of how long does he have for an appeal. So you have 30 days to file the notice of appeal. First, do you expect them to?
Oh, absolutely.
100%.
There's no doubt.
100% chance they're going to file a notice of appeal. Number two, do you think they'll be successful? Do you think there will be something that came out in this trial that gives them a successful new trial of some sort?
Well, one of the things you just talked about was what's going on outside and the outside pressures. That's going to be one of the biggest areas of appeal.
That's their best chance.
Because, you had so much going on that there was so much to influence this jury. The defense lawyer asked for a change of venue twice to try this case somewhere else, and the judge denied it. The defense lawyer repeatedly asked for the jury to be sequestered, which means locked in a hotel room somewhere for the duration of the trial.
Which they've done at other trials.
And the judge denied it. So
didn't they do that for OJ? I'm pretty sure they did that for OJ. I'm pretty sure they sequestered the jury from OJ. At least or I could just be remembering the FX show, which I'm sure was totally accurate. And I'm pretty sure they sequestered the jury. And he asked for to re-ask questions to the jurors they had already picked and do other stuff during jury selection when the $27 million verdict came in. So they've asked for all these extensions, for this change of venue. They've asked for all these things. Why do defense attorneys do it?
Well, they do it for two reasons. One is to preserve the record.
And what does that mean, to preserve the record?
That means if you don't do it, you can't appeal it. So if you don't ask for it and the judge doesn't have a chance to deny it, you can't appeal it to a higher court because the court will say, look, why should we review it? You never even asked for it.
And
so that judge never got a chance.
That's why defense attorneys have to be annoying and have to be nitpicky and have to bring up every single argument every chance they get, because they have to make sure the court reporter types it down and they can understand that this was something we thought was a big deal at the time, and look, it affected the verdict. So when you're going to come back and appeal it, you can point back to the fact that you stood up, pounded the table, stomped your feet about this issue during the trial.
Right.
You're not being retroactive. You're not saying, oh, well, maybe this could have affected the verdict. I didn't think about it at the time. You've got to think about it throughout the entire trial, listen to every word and everything that's being done.
And even if you don't scream and yell about it during the trial, you at least have to raise it, because the judge has to have an opportunity to deny it.
Okay, another question. Do we think that Derek Chauvin is in more danger now than he was, or I'm sorry, is he in more danger now than before the trial?
You know, I thought about this, and I'm thinking, what kind of a prison sentence is he really going to have? Let's say he gets 40 years or whatever he gets. Are they going to be able to put him in general population where he's out there with everybody and he get a chance to be stabbed or murdered or beaten up? Or is he going to be in isolation the whole time in order to keep him safe? You know, that's an awful lonely 40 years if you can't see anybody and you're locked in a cell by yourself.
I would assume he's going to ask for and get solitary.
Well,
Don't you think? I mean,
well, he doesn't even have to ask for it. It may be the
forced on him.
Yeah, because safety concern. Who's going to think that there's not a risk for him out in general population?
Although we saw what happened to Epstein, this doesn't always work just because you're in
well,
solitary.
that's if you want to kill yourself.
Yeah, or somebody
Or
important enough
someone
wants to kill.
right.
We're not going to get into conspiracy theories here. Okay, so what is it like when you're standing next to somebody? You've done murder trials. The first trial we did together, guy got 40 years or whatever. It wasn't a murder trial, it was attempted murder. So what is it like when you stand next to a defendant, listening to that verdict come down, waiting for the jury to deliberate and come down with a verdict where someone's life and liberty is on the line? What is it like?
Well, you have to prepare the defendant before the verdict for whatever's happened. You have to say, look, it may be this way, it may be that way, it may be guilty, it may be not guilty. Don't react, because you got to remember, that judge still has to sentence you. He's watching you at that point to see how you react and how you handle yourself. So number one, don't react. Two, prepare yourself for the worst. If you prepare yourself for the worst, then if the best comes out, you're even happier. So you've got to mentally prepare them. And it's awful, it's depressing for the lawyer, because
you do everything you can, but
by that time,
yeah.
you've been with that client for years sometimes, and you've gotten to know them really well and gotten a relationship with them. And so you really hate to see it, but the evidence, one of the things you say, you can't change the facts, and sometimes the evidence just is there.
And a lot of times, I've got a question. If he appeals, can he choose different counsel?
Yes, and most likely he will, except in this case, the union is paying for the lawyer, so the union may want him to keep the same counsel. One of the reasons you change counsel sometimes is because if you think your counsel didn't do a good job. But frankly, he did about as good as he could do it.
So there's two things. There's one reason you can change counsel. If you didn't think your counsel did a good job, they can file what's known as an ineffective assistance of counsel claim, appeal type of claim, because your lawyer did a bad job. So that's one reason. A second reason, some lawyers that practice criminal defense and do criminal trial law don't do appeals.
Right.
So sometimes they just don't do appeals, and you need somebody that specializes in appeals. But in our cases, a lot of times we have appealed.
We do both.
We have appealed the case, and one of the reasons we like to do it, him mostly, is we know the case. We know the facts. We know what happened. We know that we protected the record. We know all of the inner workings of what happened at every time the judge made a ruling throughout the entirety of the case. So sometimes we feel like we are in the best position as the trial lawyers to do the appeals. But it is up to the client. He can fire his lawyer now. I don't know how the union works, but he can fire his lawyer now, ask for a different lawyer to do the appeal. That's absolutely something that happens. There was something else I was going to say. What was the last thing we were just talking about?
Before
I can't remember. Okay, so if you have any other questions, go ahead and throw them on there, because we've got just a couple more points to make, and then we'll answer the rest of the questions, and then we'll shut it down. So when you have somebody that, that's what it was. So after the verdict comes in, and you've prepared your client as best as you can, and you get this guilty verdict, what is it like in their head afterwards when you talk to them about all hope is not gone, things could still happen, when you talk to them about next steps? How do you keep them in it? How do you keep their spirits from just giving up and being like, I'm done with this, it's over?
Well, during the course of the trial, when you're preserving your record that we talked about before, you keep a list of all those things that probably cause reversals, and maybe the appellate court will give you a new trial, or maybe the judge will give you a new trial. You tell him, look, these are all the things we have. We have a lot of ammunition here. You go through the list with him so that he understands that there are things to appeal. It is worth appealing, and you have a chance on that appeal.
What do you think the national response is going to be? It's this is a 100% verdict, basically.
Yes.
All the way down the line, 3 for 3 guilty. The jury said give him the max that you can give him, basically, as far as we didn't hold anything back. So, because they could have just done a jury nullification and for no reason given a not guilty on the manslaughter. They could have. If they didn't want to really pile on, they could have just said guilty with the worst and forget the other two, or vice versa, not guilty with the worst and convict him with the other two. They didn't do that. This was straight down the line, 100% guilt, not 100%, beyond a reasonable doubt guilt. What do you think the national response is going to be to this?
I think it's going to be positive. And I tell you, you really can't, again, we're not condemning the entire police department, just this action. Number two, the whole world saw that video. So the prosecution basically said, believe your eyes. So I think everybody's going to see there was a reason for these verdicts. It wasn't out of the ordinary. It wasn't because of prejudice or bias. There really was evidence for this verdict.
And they weren't convicting him of all of the police brutality and all of the police misconduct of all time. They weren't convicting him of the murders of all these other people that have been, injured, murdered, or disparaged, or whatever happened to them at the hands of the police. That was not put on Derek Chauvin's head. That was not put on this defense attorney's shoulders. This was isolated to just this case.
Right. It was a really, really unique item because of that video. And because of that, the whole world got to see it. And I think it's going to be a positive result. I don't think we're going to have the same problem we would have had, obviously, if it was a not guilty verdict.
So another question that we got is, if he appeals, would it be a good idea to put him on the stand? So that could be, I guess, if he gets a new trial, do you think they'd change strategy because he didn't testify? Usually it's a strategy. So first question, let me break it up into two parts. I don't know if this is the way the person was asking, but can that be a reason for appeal that he decided not to testify and he lost?
Not really, because
if you
watch the trial,
yeah, they do a colloquy.
He actually was questioned by the judge if it was his decision alone to waive his constitutional right. But that question, I think, also is really another question in that some people may think he can testify at his appeal. Appeals are strictly based on the transcript of this trial. There is no testimony, no new evidence, nothing is presented new at the appeal. It comes up from the trial, so he has to win the appeal, go back down for a new trial before you'd even have a chance to testify.
So the appeal is contained within the record. So if it didn't come in at trial, it can't come in at the appeal.
Right.
No matter what. If you didn't make an argument as a defense attorney, you can't make that argument now. If you didn't call a witness, including the defendant himself, you can't call that witness now. You can't do any of that stuff with a caveat, right? So you said no new evidence can come in an appeal, and I just said no new witnesses can come in an appeal, unless you find something that you couldn't have known about before, right? So if new evidence comes up, like it happens with DNA evidence that didn't exist in some trials, you can do an appeal based on new evidence.
First, the new evidence has to be presented to the trial judge.
Right.
Before you can appeal it.
So explain how that works.
Well, first you have to file a motion with the court that there's new evidence, and then the trial judge who tried the case, then you present the evidence to the trial judge. If he denies your new trial based on new evidence, then you appeal it. But again, you only appeal on the record you placed before that trial judge.
Right. So do you think that it was a mistake not to call the defendant in this trial?
I do not. I think it was a smart move. I think the jury was either going to convict or not convict based on what was presented, and I don't think they would have been changed by his testimony. Plus, I think there was way too much to cross-examine him on. They had so many of his own people testifying. They're going to go through each individual witness says, well, he said this, what about this training, what about that training? Too much to cross-examine him on. He wasn't going to change anybody's minds. It wasn't worth putting him on.
So one of the big questions I think that would have happened on cross would be why? Right? Why didn't you get off of it? Why did you put him in that position? Why did you do this? And I don't think he would have been able to give a good answer for that. Because that's the question nobody else can answer. Why? Why did you have this look on your face so unconcerned with a guy that was dying under your knee? Why did you do all this? Because they can say, police training, or he just did this, or he did what we were trained to do, or he put him in handcuffs, or George Floyd did this. But nobody else could answer the question as to why he did what he did for as long as he did with seemingly no remorse, right? I mean, I think that would have been pretty condemning.
You're right. But I also think if you remember, they did have him give one phrase in that trial.
Right.
It didn't come from the testimony.
Right.
It came from a body cam. They put on a body cam and he explained that the crowd was unruly. He was a really big guy, and he had to hold him down. So he was able to give a little bit of a statement, but no, it would have been too big a risk to put him on.
So one of the comments said, I feel like they would have destroyed him on cross-examination.
I think you're right. Absolutely.
Okay. All right, another question. Would you have done anything differently as, I assume, the criminal defense lawyer in this trial?
It's hard for me to say, number one,
we don't know everything that
I did not watch every day, all day of the trial. So I can't say that. I can say that what I did watch, I thought he did a very competent job.
I thought so too. I thought he did a really good job. He's got what he's got. You can't change the facts.
I probably would have given a shorter closing argument, because I think his closing argument was like 3 hours. I think I would have given a shorter closing argument, but he did the best he could with what he had. I really believe he did a decent job.
I agree. I think he picked angles. He had to pick some angles. Unruly crowd. George Floyd, had other reasons for his death. Big guy that was hard to contain, those kind of arguments. That's why they had to, subdue him. He tried to resist arrest. He committed a crime. That's why they were there. I think he tried to pick the best angles that he could. I actually think he did a really good job. I thought he was a really likable guy, too, throughout the trial. He wasn't nasty. He wasn't contentious with the prosecutors.
And it was a smart strategy to be all alone at that defense table. He was one guy against all these prosecutors, and I think that looked good.
Do you think he has any chance to win any of his appeals? So we've talked about this a little bit. Which one do you think has the best chance? I mean, we kind of talked about the outside influences and the outside forces, the $27 million settlement, the other police killing that happened at the same time, and they got denied all of their requests to sequester the jury or to move it or to delay it or to re-question the jurors they've already questioned and picked. Do you think any other reason besides those outside forces would be a good chance at an appeal?
The only one that I think might have a chance is what's called cumulative evidence. Maybe the prosecutor put on too much evidence. Too many people testified about the same thing. So they may have done some piling on that might have an issue. But to me, the absolute best issue is no change of venue and no sequestration of the jury.
Yeah, especially when it wasn't, just on its own, you could have made the argument that they should sequester the jury or change the venue, meaning have the trial somewhere else. Why is that important? Let's talk about that. Why would the change of venue of where you pick your jury from be important in a case like this?
Well, you think about it. These people, maybe you got a jury that wasn't directly affected, but they knew somebody that was affected. Or they were sitting there. You'd think if you lived in that city, how many times was that video played on television in that city?
And think about, they have friends whose stores and businesses were destroyed in the riots, and they have to go through all this, the defund the police stuff. They were living it, where if they would have gone some other area the entire country, the entire world watched the video and knew what was happening. But if you take it to a different venue that's not right in the midst of it, then I think that's a pretty good argument that you could have had a more fair and impartial jury.
It would have been easier to pick a jury for sure, because even some of those jurors had seen the pictures, it was not easy to get a jury even in the case.
Yeah, I don't think personally that that's going to be a reason they win on appeal. We're just saying I think that's the best chance that they have, is kind of these outside forces and effects that may have had an effect on the jury, may have pressured them to make a certain decision, or they came in with their mind already made up, and they didn't give them the presumption of innocence throughout the trial. Because that's really important. You've got to come in, right, and he is innocent until you hear all the evidence. So when you ask in jury selection, right now, if I ask you for your verdict, Mr. Juror, what would your verdict be? It has to be not guilty, right? And explain why that is.
Well, because the only thing they can do when they're sitting there and heard no evidence is presume him innocent. So if you presume him innocent, you've heard no evidence, it's got to be a not guilty.
Right, because the burden is on the prosecution to prove beyond a reasonable doubt with evidence that he's guilty. So if they haven't given you any evidence, they haven't proven anything to you, then it's not guilty. And that's how you have to do. Picking a jury is really hard in cases like this. Do you have anything else on your list you want to hit? We're going to give it about 1 or 2 more minutes. If there are any other questions, we'll continue to go through them. If not, we'll probably sign off here pretty soon.
No, you covered everything. Good.
All right, so what do you expect to happen at the sentencing here? So we know that there's going to be an 8-week period. I'm sure we're going to see some things about the pre-sentence report. Well, how does being a law enforcement officer affect the pre-sentence investigation, the PSI?
Well, he's probably going to have a clean PSI. Obviously, he's a police officer. He's going to have no prior record. He's probably going to have a clean PSI. Now, I don't know what his internal affairs file looks like. I don't know how many complaints maybe he's had. My guess is I'm sure that'll come up. The judge in this case, he's been very fair. And I've got to say he's been very level-headed. I haven't seen him really lose his temper. He did get a little irritated with the congresswoman that spoke the other day, but
is that Maxine
unusual.
Waters?
Yes.
Okay, so somebody asked Maxine Waters' comment issue. Like, could that be an appellate issue, what she said?
It could be an appellate issue. In fact, the judge said that this may have given you another issue to appeal. The judge said that from the bench, which is very unusual. So he did get, you could tell he was really irritated by the fact that people were doing this stuff and not allowing a fair trial to proceed, but trying to interfere with the trial.
Could he have elected a bench trial? That's another question we got.
Yes, he could have elected it, and
the state would have had to agree, though, right?
Yes, and it wouldn't have been a good idea.
You think he gets convicted? You don't even think the judge would have split the baby?
No, I think the jury, you had your best chance with the jury, because, you know, the statement is,
I don't know if I agree with that.
You always got a chance with the jury.
Not in this case. I didn't think he had. I didn't think he had a 1% chance of not being convicted on at least one of the charges with a jury.
This judge has seen 100 trials, or 100, maybe 1,000 trials, and the fact is, he knows what the evidence looks like. He's going to look at this evidence and say, "Gosh, this is a lot of evidence," and I think the evidence was pretty overwhelming.
One of the things that's interesting with a bench trial, and considering that as a lawyer, is the jury doesn't hear so many things. Like, there are so many things that are inadmissible to say in front of a jury that the rules of evidence keep out of a trial. So a jury never hears a lot of things that you or I might think are really relevant to the case, and we think that's really important if he had done this before or whatever it may be. A judge, when you do a bench trial, has heard all of it. So if your client is a horrible person addicted to drugs and whatever, the jury may never hear that if it's not relevant to the case. The judge knows all that. So, I mean, everybody knows a lot about this case specifically, but in a bench trial generally, you have to worry that the judge has kind of already made up his mind or her mind and made some decisions about your client. So it's kind of scary to go in front of a judge because they know everything, even things that are not supposed to be taken into account. A jury only knows what's admissible, what the rules allow them to know, and what the lawyers are allowed to argue in front of them. So that's an important indication between a bench trial and a jury trial. Thoughts on the defense lawyers? What have you done differently? So we've answered that question. It's a little bit back in the video. We're going to post this on YouTube as well if anybody wants to go back and listen to it. Generally speaking, just the quick answer is we thought he hit most of the angles that you could. We think he did a pretty good job. He was pretty likable. We don't think he had a ton to work with. So generally we think he did a good job, but we don't think that there was really a lot to work with on his position. Did the judge opt out because he didn't want to be blamed for the verdict?
It wasn't the judge's decision. I think that's what they're asking about.
Okay, so it was the defense that did not want to do a bench trial. And usually that's the case. Usually the defense in these kind of cases and the plaintiff in a car accident case doesn't want a bench trial because jurors are people, they're our peers, they're just people in the world. They make the decision based off common sense and their experience. They don't make the decision from a jaded position of knowing the law and seeing hundreds of verdicts and seeing hundreds of people commit crimes or get in car accidents. And so it's the system that's set up that's best in our judicial system, which is why we do it this way. So whenever possible and whenever we think is best, which is most of the time, we want to put it in the hands of the jury. We want to put it in the hands as lawyers and as clients of the people that have to deal with the same system as we do. So usually you're doing it with people in society that if this case ever happens to them, they think, I could be sitting in that person's shoes. I could be going through this. And this is called the golden rule. You're not allowed to argue this in closing. You're not allowed to say, what if this were you? What if this were you, Mr. Juror, being accused of all this stuff? What if this was you? How would you feel? How would you want a jury to think about this? We're not allowed to make that argument. That's one of those rules I just talked about. But that's what we're thinking as lawyers is we want them to understand this affects all the citizens in our country, and that's why the citizens should make the decision, as opposed to somebody with a law degree that's a judge on high. All right. I think that's a wrap. Any other questions, feel free to leave them in the comments or go to YouTube and put them in the comments and we'll answer them. I'm sure we'll do more videos probably when the sentencing comes down. We'll talk about whether we think it was a fair sentence. What's your guess? You think it's the 12 and a half years and that's it? Or you think it's going to be more?
More. The judge is going to aggravate it.
You think it's going to be 40 years?
I don't know about 40, but you want a wild guess?
Sure.
All right, 25.
You think it's just going to be 25 years straight?
25 years straight.
I have no idea. I was going to say 12 and a half years, but that seems
he's going to aggravate that 12 and a half.
I have no idea. So I guess our guess is going to be 25 years. I'll go with him on this one. Thanks for listening, guys. We appreciate you being on. We appreciate you listening and taking this ride with us. If you have any questions, like I said, hop over to YouTube and ask them, and we'll be doing more on this in the future. Now I've got to figure out how to save this. What are the aggravating factors? All right, last question. Let's get in. I think we've hit them a little bit.
We
did
that.
it already?
Yeah.
All right, so we've hit the aggravating factors. Give her one on the way, or him one.
The aggravating factors were children as witnesses, police action under color of law enforcement, and Floyd being a vulnerable victim.
Yeah, abusing his authority as a police officer.
Right.
All right, thanks, folks.